Just to get the course right of this matter, I think the first question you have to answer is the maintainability of this review, and we'll come to the facts later after reference. So you'll have to assist us that under 186, what's the question of law? Because a decision has been given by the Supreme Court, review has also been dismissed. Now, that is the end of the matter. On what principle? आपके जो grounds अभी तक आपने दिखाए हमें, they are talking about as if you are vesting us, your argument is as if Article 186 vests another appellate jurisdiction to review the existing judgments of this court. And all the grounds that so far that we've seen are factual relating to the judgment itself. And the question is, there is finality attached to the decisions of the court, right or wrong. There could be bad decisions passed by the court, they're final. So the question is, what is the question of law that is for us to give our opinion on when the matter has already been settled by the Supreme Court? So if there is a question, you'll have to articulate. Is it outside the judgment, or because the factual position of the judgment cannot be touched? That's been decided. Review dismissed. That's the end of the matter. And we have no jurisdiction to review second review or look at it through a second appeal. There is no such concept under 186. So 186 at best would be a question of law which you'll have to articulate before us. It cannot arise out of the factual position of the judgment because that's settled. We can't look at the facts. You'll have to go outside if at all there is any argument, which I don't see in the ground so far. So that's a difficult question. We already have decisions of this court and of the jurisdiction from India also, which say we can't touch a judgment given by this court and look at it at a policy level. If this happens, then tomorrow there could be references. We keep opening all our judgments. So you'll have to really articulate a point. Under what basis do we go into 186, which I would imagine is a difficult one. So please concentrate on the maintainability and the constitutional question. How do we open this matter, if at all? How?
Your Lordship is right. See, under Article 186 of the Constitution, 3 tests have to be met before an opinion is given. It should be of public importance and question of law is involved. And if these 2 tests are met, then the 3rd test is with regard to giving an opinion by this Honorable Court.
Mr. Naik, the 186 says that the question of law is for the court to determine.
Yes.
The question of public importance is for the President to determine. That's for the President. We don't. That's not our problem. Our problem is, what's the question of law? Is the question of law saying this judgment is wrong? Is that a question of law? That is not, to my mind, frankly, speaking for myself, does not constitute a question of law. The judgment is wrong. There has to be more than that, and you'll have to come up with that argument as to what it is. Because if this is the policy, then tomorrow the President can start sending references, start revisiting all the judgments that we've ever given. That will not be a correct way of going about it, and you understand that.
I understand.
So we'll have to come up with, you'll have to come up with something to tell us. What is that novel argument that shows that 186 can be invoked in this matter? So please, this is not easy.
And one thing I would like to add, Attorney General,
decide anything, we have to give the opinion.
Yes, my lord.
Therefore, what has been said till now, that relates to the determination of something by this court. That is not the scope.
It's actually a very serious question. Because when you say it's a question of law, the law has been decided in the judgment. Whatever judgment Supreme Court gives is the law of the land. So this is the law. So what's the question of law? So you can't say this judgment is wrong. It's not a question of law. There has to be something else.
Basically, the entire reference is based on the interview of the judge. That can be a question of law because it was a factual aspect that has been interviewed by some TV reporter after his retirement. And whether this can be a question of law because the entire reference, the crux of the reference is based on that interview. You have to address that, whether it will be converted into a question of law, whatever he has said. Because there were 3 dissenting judges also. He could have been a dissenting judge of that.
My lord.
What was the pressure on him? Why is...
Mr. Naik, let me take you to the real, what you think your question is. Your question is that during a deviation period or any dictatorship, the judiciary is not independent and they don't decide independently. That's a big assumption that you're throwing at us. You're saying that in any martial law, the judiciary is not independent. Hence, this is not a fair trial. You'll have to build a very strong case that how do you break that assumption that the judiciary is independent even during martial law period? And if it's not, what's the evidence? And if it's not, then what is the consequence? But that's a big assumption you're challenging. You're saying that in any deviation period, the judiciary is not independent. That's a big assumption to touch.
I will try to persuade your lordship on this point.
Can I just, before we get into,
or they should have
we're not,
can later on, other things will follow.
okay, now I think my brethren have raised some very important questions, and you also realize the significance of these questions. We need not tell very experienced counsel standing before us. There are undoubtedly constitutional questions involved, and we need two kinds of assistance, one on the constitutional plane, and the other, if you overcome the constitutional plane questions or questions of maintainability, then expertise on the criminal side. So I've noted that there were a number of constitutional experts who are no longer in this world. So I think we need to maybe appoint a few experts on both the matters as constitutional as well as the criminal. We'll first hear the constitutional experts, and then, depending on where we stand, proceed to hear the criminal experts.